since we want to make sure we have time left for Q&A at the end.
Sure.
So,
yeah, Kevin, I'll just say really quick, this is Kelly
Okay.
Erlacher with Lewis, Longman, and Walker. I just wanted to thank everyone for being here today. Before I turn it over to Kevin to introduce the speakers, I just wanted to make sure everyone is aware that we are recording today's session. So to ensure a quality recording, we would appreciate if everyone kept their cameras off and their phones muted or your iPads muted. And we will be allowing for some time at the end of today's presentation for question and answer. So please hold your questions to the end of the presentation, and you can use the chat feature in Zoom to submit your question. So with that, I will go ahead and turn it over to Kevin.
well, good afternoon, everyone, and thank you for attending our Lunch and Learn today, presented by Lewis, Longman, and Walker. The topic is expert witness in the Zoom era. So if you'll go ahead and move to the next slide, Kelly. So your presenters today will be Kevin Hennessy, myself. I am a founding shareholder of Lewis, Longman, and Walker. I am also the shareholder in charge of our St. Petersburg office. I've been practicing, I'm also chair of our litigation practice group. I've been practicing for over 30 years, doing litigation of environmental, land use, property rights, local government matters in state court, federal court, and administrative court. I am also a Martindale-Hubbell AV preeminent peer-rated attorney. Your next, and I will be speaking on the Zoom basics and expert support. Next speaker, Fred Ashauer, who will be speaking on preparing and delivering expert testimony. Fred is our most recent shareholder. Congratulations, Fred. He is chair of our Transportation and Infrastructure Practice Group and vice chair of the Litigation Practice Group. So he's breathing down my neck on that. Prior to joining Lewis, Longman, and Walker in 2017, Fred served as general counsel for the Florida Department of Environmental Protection. Fred has focused his practice since joining the firm on the litigation of complex federal and administrative environmental permit challenges, environmental permitting, defending clients in enforcement actions brought by environmental regulatory agencies, and the legal issues associated with the remediation of contaminated property. Fred is likewise a Martindale-Hubbell AV preeminent peer review rated attorney. Finally, Amy Petrick, and Fred is in our Tallahassee office. Amy Petrick, who's in our West Palm Beach office, will be speaking to you on the use of exhibits over Zoom. Amy is board certified by the Florida Bar in city, county, and local government law. Amy has experience with both bench and jury trial work in federal and state court and before the Florida Division of Administrative Hearings. She is handling also state and federal appeals. Amy represents a number of clients on a wide variety of land use, administrative, regulatory, construction, and contractual matters in state and federal court and administrative forums. So those will be your speakers. And as I say, we'll try to get through this in time to leave about 10 minutes for questions at the end. So Zoom basics. The first thing that you'll need to know about being an expert witness in the Zoom era is the platform and the equipment that will be used. Now, we'll be discussing and focused on the use of the Zoom platform, but different platforms exist and are used by various courts or required by various governmental entities, such as Teams or WebEx. And those agencies or courts sometimes shy away from Zoom based on past concerns about security risk. I'm sure you've all heard stories about Zoom calls being bombed by uninvited attendees, or simply by people who are looking to disrupt public meetings. The equipment under any of the platforms, the equipment's going to be the same. You're going to need a camera, a device that has a camera and a microphone. This can be so much as a cell phone. It can be a personal computer or a tablet. But for many, for most expert use, witness use, you'll really want to have a dual system, either multiple screens, or using a phone and a tablet, or a phone or a tablet and a personal computer, so that you can have multiple windows available to you. Because while in the past everybody worked off of paper, now your exhibits, transcripts, etc., that people are going to be referring to during the course of a trial will be most likely on some digital form, either a link, a share file system, or your own litigation support software. So we definitely recommend. I personally, in the multiple hearings I've been involved in now, have used a system of my my iPad, which I'm on now, and my computer screens. Next slide. So getting into some of the Zoom basics, some of the do's and don'ts. First off, you need to know if you are going to be, as your expert, you're going to be allowed to watch the entire proceeding, or whether or not you need to be left in a waiting room until a judge admits you. That is often dependent upon whether or not the rule of sequestration has been enacted, meaning that all witnesses are not allowed to listen and hear the testimony of other witnesses, so their testimony is not shaped by what they heard. In the case of experts, though, normally there are arrangements made to at least allow experts to hear the testimony of experts that they may be entitled to rebut, or certainly in administrative hearings, it's quite common to be allowed to have your expert witness sit with you through an entire trial. So in the context of a Zoom situation, you would be entitled to to be on and listening to the entire trial, but you need to confirm with your attorney how much access you're going to get. The rule number one in logging on, nope, we're still on this. Rule number one on logging on is knowing if your camera's on and your microphone's on. And as indicated in this this slide, there is a bar. You will see a little microphone. You will see a little camera. And on means no red line. Off means red line / through it. This is probably the most common mistake made, is people leaving their microphone on, or leaving their camera on and microphone on when they're, for example, walking away. There's a break, and everyone's now listening to you perhaps get on the phone and talk to your attorney, or talking to your staff about other matters, or going and eating your lunch, all of which is something you want to avoid. So often, get in the habit of knowing of turning your microphone and your video off whenever you're not needed, whenever you're not participating, or certainly keep your microphone off whenever you're not speaking. It's less of a faux pas to start speaking with your microphone off. It's easy enough for people to tell you to turn it on. You also want to keep your microphones away from your papers. The sound of shuffling papers can be very disturbing, or if you're typing or talking to others, you want to be careful. You also, as indicated at the start of this presentation, you want to make sure your cell phones are off, or any kind of notification alarms that you may have on your computers that tends to go off. I was in a proceeding where every time somebody received an email, they were getting a beep or an alarm, and it was quite disturbing. And unfortunately, he didn't know how to turn it off and had to basically mute himself through the entire proceeding. Next slide, please. So different types of views that you get, as demonstrated by this slide. You have views, different views, both speaker views and gallery views. Speaker view is when you just see the person speaking. Gallery view is when everybody who has their camera on can be visible. And it will be visible, gallery view can be visible both in the shared screen situation or the non-shared screen situation. This slide shows at the top, our lovely models from Lewis, Longman, and Walker, demonstrating what the gallery view looks like without a shared screen. The bottom part of the slide shows what a gallery view would look like while someone is sharing the screen and showing apparently a presentation on Zoom basics. And you do have control of your screen. If you look at that of your view, there's either a button on the top left when the screen's not being shared that can adjust from gallery to speaker only, and as indicated in the depiction of the gallery on the bottom part of this slide, there is a little plus button which would allows you to expand to gallery view or to redact to speaker only. And for sharing screen, it's a process of going to the shared screen button as indicated on the left hand of this slide, going to shared screen, then identifying what you may have many different pages open or screens open on your computer, and the Zoom platform will indicate a variety of open screens, and you need to click then on the screen you want to share, and then press the shared screen button again. Once you're in a shared screen mode, that mode will remain until you choose to press the stop sharing button. And there's strategic questions about sharing screen or not, and it's often why the attorney wants to be in charge of sharing screen, because there may be times when he doesn't want the judge, for example, to be able to see anything but the document that he wants the judge to look at, or there may be a desire to take the shared screen down as quickly as possible so that the judge can be continuing to make eye contact with the gallery or his witness in particular. Go ahead and go to the next slide. So expert support. This is really all about communications with your attorney. Historically, you'd be at counsel table, you'd be in the same room, and so you could certainly just talk to one another, pass notes to each other, whatever you were comfortable with. Now in the situation where it's very likely that you will not be in the same room, you will be attending from your own location, the issue of how to provide the attorney with the type of support that he wants in terms of issues you see, questions you want to raise. Perhaps the opposing expert has made a significant mistake that you want to point out. So how do you bring your attorney's attention to that? Text, emails, using the chat function on the Zoom are all alternatives, and they all have downsides. The downside with regard to all of those is that it's not necessarily real time. Your attorney will see your text, email, or chat statement when he goes and looks at it. And so if you're not complete in your thought, it may be very difficult for your attorney to understand what it is you're trying to communicate. Chat rooms also have the concern about chatting with more than just your attorney. There is an chatting to all button, and so the judge or the other attorneys may hear you making comments, disparaging remarks about the witness on the stand, which may not be something that you want to share. Of course, the other thing with emails, texts, you could be distracting or interrupting your attorney while he's or she is trying to maintain concentration on listening to the testimony being given. So really, a good attorney will ask for breaks or take advantage of breaks given by the judge to speak to you over the phone or read your emails and texts during those breaks. So emails, texts should be very clear in terms of what it is information you need to convey. And I believe that that's all I have for the do's and don'ts and an overview, and I'll pass it on to Fred for preparing and delivering expert testimony.
Thank you, Kevin, and thank you everyone for joining us. Good afternoon. So I'm going to talk to you about providing expert testimony at deposition and at a trial or final hearing in the Zoom era. But I'm going to spend a couple slides on general sort of practices that you should be engaged in when it comes to providing that testimony. And these rules apply whether you're in person or whether you are providing testimony via Zoom. So since they're uniform, I thought I would lead off with them, and then I have a very specific slide on do's and don'ts for providing testimony in the Zoom era. So first and foremost, the case is really set in our preparation. And so if I can ask you to remember one thing about this slide, it is prepare, prepare, prepare. Prior to your deposition, you should have had meetings, plural, with the attorney who will be handling the case for your client. You should have already discussed with him or her your opinions, had the opportunity to work through them. You should have your documents in order, and your exhibits should all be prepared prior to your deposition. Most of these cases, there is a requirement that your final opinions and your final exhibits for hearing be prepared and ready for your deposition so the attorneys representing the other side can ask you questions about it. So prior to you ever uttering a word in either deposition or in your deposition, you should prepare, prepare, prepare. Next slide, please. So Kevin joked earlier about rule number one, the number one rule. There was an inside joke because he knew this slide was coming. So the number one rule for you as an expert is to tell the truth, the whole truth, and nothing but the truth. That's if you've, and I know a number of you, I've worked with a number of you. I am working with some of you right now in that capacity. And you will or have heard me say that that is your number one obligation. All of your testimony has to go through that lens. But then you've also heard me talk about Rule 1A. And that is that the attorneys, we craft the narrative for the case. And so we might ask you to present your testimony in a certain way that is different than the way you would present it. That doesn't mean we're going to ask you to say things that are factually untrue, but it may mean that we ask you to say it in a different way while still being factually true. And the example I give is the glass is half full, the glass is half empty. If the glass is half full, you're typically viewed as being a positive person. If it's half empty, there's a different connotation. We may want a positive connotation to your testimony. So if your natural inclination is to say the glass is half empty, I might ask you to say the glass is half full. Both of those statements are factually true if the fact the glass is one of those, it's halfway full, but they present that different story and they go with the narrative. So that's rule one. Number one, always tell the truth. Number 1A, remember the attorneys set the narrative and you'll need to work within that narrative. Next slide, please. All right, so you've prepared your exhibits. You've talked to the attorney who you'll be working with about your opinions. You're ready to go. You show up for a deposition. The number one rule applies. You'll hear me. That's the most critical thing. You're going to take an oath. You're subject to perjury. If you don't tell the truth, we could be in trouble if we suborn perjury. Neither of that's good for any of us. So number one rule still applies. Remember that. From there, it really is pretty simple. And if you remember one thing about this slide, it's listen carefully to the question. That is critical. Your obligation under when you're under oath and when you're performing services for your client is to provide your testimony in response to the questions that you are asked at your deposition. You have an obligation to provide a complete answer, but we would also ask that you provide a succinct answer. So listen to the question, formulate your opinion, and then provide a complete and succinct answer. When you are being deposed, it is not your responsibility to educate the lawyer to whom you are speaking. In fact, that lawyer probably wants you to say as much as possible because they are taking your deposition for two reasons. The first is to learn what your opinions are. Okay, that's an admirable goal. The second is to use your testimony against you when it comes time for you to provide that testimony in your final hearing or at the trial. So as long as you are taking your time to answer the questions and providing thoughtful, complete, succinct answers, you'll do just fine. Before I go to the next slide, I want to hit one of these other ones because it's important. Don't try to out-lawyer the lawyer. Don't worry about the next question that he or she may ask or the question beyond that, or what are they angling at. Don't worry about that. It is the lawyer who's sitting on your side of the table if we're in person, or the lawyer who's been working with you if we're via Zoom, to follow up on those questions or to deal with it later on at the final hearing. Next slide, please. Okay, so you have provided an exceptional deposition. You got all your opinions out there, your exhibits are all prepared. You spent 6 hours being examined by the opposing attorney and you walked away feeling great. What do? Now we go to final hearing. When we are putting on our case and you are working with the attorney who's been working with you the whole time, that's what we call your direct testimony. That's where the case is won. When you provide your direct testimony in response to those questions, that is critical. So what are the rules to apply during direct testimony? Well, you apply the deposition rules. You still, even if I'm the attorney that's been working with you and I'm asking you questions, you have to be careful. Listen to the question I'm asking you and provide me a direct answer. Now, depositions and trials are slightly different, as is direct and cross. So you'll want to work with the attorney prior to testifying. If you've worked with me in the past, you know that I will have a list of questions and I will share them with you in advance of your testimony. I will also caution you not to be inflexible, which is a huge don't in your direct testimony. And the reason is, it is not uncommon. In fact, it is commonplace for me to want to ask you a question in follow-up to something you said in your direct testimony because of something I heard a witness from the other side say earlier on in the trial, or something that occurs to me in the time period since we last worked on your testimony and that day, for whatever reason. So you cannot memorize the questions and answers. You just have to know your opinions and be responsive to the questions that the attorney asks you. So next slide. So you had a 6-hour deposition and you were in direct with me for 2.5 hours. And now I say, Your Honor, I have no further questions. The lawyer for the other side begins. What's your responsibility on cross-examination? It's the same responsibility you had at deposition, the same responsibility you had on direct examination. Listen to the question and answer the question. So that's a theme, and that's the most important thing for you to do. Listen carefully, answer carefully. I've included more don'ts than do's in cross-examination because here is where we're looking out for landmines, if you will. So first and foremost, do not argue with the opposing counsel. It does not make you look good. It makes you look like you're a biased advocate. You want to be an independent scientist, an independent expert consultant who has formulated opinions based upon research, studies, etc. Not because you don't want to be appeared as someone who's in there striving for a specific outcome. And when you argue with the opposing counsel, that's what it looks like. Don't contradict your previous opinions. Now I'm going to add a caveat to that. If you worked on something 27 years ago and it was a seminal paper on, say, hydrogeology in an area, and in that time there's been significantly more research in this area, and it's caused not only you, but the community to change their view of that particular, let's say, aquifer, since I was talking about geology. At that point in time, it's okay for you to hold different opinions than you held 27 years ago. It would be bad for you, however, to do a study on a certain area, reach a conclusion about it, and then 1 year later or 2 years later, offer an opinion that contradicts it, especially if it's not based on any scientific reasoning. And this last don't express opinions beyond your area of expertise. Caveat to that is, many people whom I've worked with don't like to call themselves an expert, and I think that's a great character. They're humble, and that's fine. But in fact, you're being called to provide testimony because the attorneys who talk to you, they do in fact believe you are an expert, and they believe you will stand the scrutiny of the challenge to your credentials if you were challenged. If you spent your entire life modeling water flow underground, and someone asks you if you're an expert in modeling water flow underground, and your humble response would be, no, don't do that. You are in fact an expert in modeling water flow underground. So don't get outside your swim lane. Now, I would say for that person who spent their entire life working on groundwater models probably doesn't want to express an opinion on how jet airplane engines work, as far as, that they would satisfy the criteria to be considered an expert in that. So don't get outside your swim lane, but firmly assert your place in your swim lane. Next slide. So this slide is very important for a number of reasons, and it has to do with, do you have the big picture? Ultimately, we're going to trial to try and prove that certain things do or don't make sense under the applicable regulations. We're going to, if we're supporting the application, we're going to try and prove that the application satisfies the applicable criteria. So if that happens to be an environmental resource permit, then it's our responsibility as attorneys to put forward a case for our client, the applicant, that their application satisfies and checks all the boxes for an ERP. You need to understand which provisions in those rules your testimony supports. And through that, you can help to understand, you'll understand, and you can help the attorneys to establish the narrative, the story necessary to support us when we're writing our proposed recommended orders or PROs. So talk to the attorney, understand what provisions of law they're talking about when they talk to you, or what do they want you to help establish. If you're a consultant and you've been processing permits with the agencies for decades, you likely do understand that, but you should make sure that you and the attorney are on the same sheet of music. So ultimate facts are the facts we're trying to prove, that water flows at this rate underground based upon this pumpage rate. Ultimate conclusions, that water pumpage will not result in drawdowns that will have a detrimental impact to surrounding wetlands. Those are the types of things you need to understand, and then we would tie that into the applicable regulatory criteria. It's important for you to know that as you're preparing for deposition and final hearing, as you're putting together your exhibits and your opinions. Next slide. All right, so the reason we are here today, providing testimony in the Zoom era. So first and foremost, whether you're at deposition or you're at final hearing, all the rules I just gave you still apply. They absolutely still apply. It doesn't matter that simply because you are in your, like I am now, master bedroom, talking to a bunch of people who are appearing in the gallery view on your iPad. All the rules still apply. But there are some additional ones that, as we have gone through this pandemic year, people starting to get very comfortable on Zoom. And while it's cute in an internal meeting for someone's dog to rush in, or the kids to play in the background, or someone, you do appear in shorts and a t-shirt at a meeting, none of those things are okay if you're providing testimony, whether it's at deposition or a trial. You still want to dress appropriately. So you'll notice we dressed appropriately for today. I have a suit on. This is how I would appear in court. I would ask you to do the same. If you were appearing for a trial and you were actually going to sit in a witness stand, you would want to dress in appropriate attire. You want to put on the suit and tie. You want to look into the camera. You want to remember if you are at a final hearing, there is a judge on the other end of your camera, so to speak, who is looking at you. And you want to give the judge the appearance of you making eye contact with them. So look into the camera. It's common to see people doing this on Zoom conferences, doing this on Zoom conferences, doing this on Zoom conferences. We don't want that. We want you engaged and we want you looking into the camera. Your background matters. So I actually chose my master bedroom today. It's my makeshift COVID office for that reason. It's neat. There's a fan, there's some blinds, nothing out of the ordinary here. You can also use other backgrounds if you so desire. This is one that we use. It's got our logo on it. That's fine if you want a green screen. Perhaps you don't like to make your bed. Perhaps you're working out of your master bedroom and you've just piled a bunch of laundry on the bed. Use something like this. Remember, though, that it is in fact a professional setting. So you may not want to be sitting on the Iron Throne. That's probably not a picture I want of you providing testimony to an administrative law judge in a final hearing. So the background matters. You know better than anyone what your COVID home office is like. If it's noisy, if there are dogs barking, then I want you to consider maybe changing that background. Consider renting a hotel room if you don't have a quiet COVID office. When it comes time to provide your testimony, and this is critical, I need you to pause, and we'll talk to you if you work with us about thinking, and we already talked about thinking when providing an answer, but in this era on Zoom, pause prior to providing an answer. So Amy and I just finished up a 2-week trial in January. During the deposition of one of our experts, the attorney asking questions and the experts sort of got into this pattern where there was a question and an immediate answer, a question and an immediate answer. Unfortunately, one of the questions was objectionable, and I had to jump in with an objection, and nobody heard it because my witness jumped right upon the question. And then a fight ensued, an argument ensued between me and the lawyer as to whether or not I was timely with my objection. So pause to allow the attorney to object if appropriately. You need you to speak slowly, clearly, and project your voice, enunciate to make sure that your testimony is clearly recorded. That applies in person too, but more so over Zoom. To help you ensure that you get accurate testimony on the written paper, test your AV equipment in advance if you can. Do an internal Zoom with the lawyers you're working with to make sure all your settings are just right. And lastly, avoid rustling papers or avoid unnecessary noises on your end. And that's whether you're in a hotel room because you rented an office space or whatever. If you have a bunch of papers on your desk and you're rustling them around, that can get picked up on the microphone and become distracting. And actually in that regard, if you're testifying, you need to treat it like the witness stand anyway. You wouldn't bring those things to the witness stand because they'd be subject to be reviewed by the attorneys examining you. The same applies in the Zoom era. So you'd want a nice clean area. You would only want things in front of you that your attorneys that you're working with had authorized. And if you do have those things, you need to make sure you're quiet handling them. Next slide. So I know I'm about out of time for my portion of it. So I'm just going to point to a couple of these. These are some funny things, but they're true. I'll just go to the very bottom one. This is a question and answer from a case. And your lawyer told you what your testimony would be, and the answer was yes. That sounds like that witness misunderstood Rule 1A. The lawyers do control the narrative, but they should never tell you what your testimony is. If they followed rule number 1, they wouldn't have answered it like this. So there's some funny ones on there. We'll make this presentation available to you if you'd like. Next slide, please. So this is perhaps more important. These are things that a judge actually said. And so, for instance, the fifth bullet point, the expert's hypothesis is not supported by engineering studies or equivalent weight. So prepare. If you've worked with an attorney in advance of your deposition, you should never run into this type of issue with your final opinions. They should be supported by the full weight of the scientific community in your area of expertise. Another one I like on here, and I brought this up earlier about not changing your opinions, the second bullet point. Petitioner's expert opinion objecting to the project differed from his prior scholarly study of the same pass. And his study supported the efficacy of the proposed project, but he was opposing it in the litigation. So that's the conclusion of my portion of this. We will have some time for questions and answers, but at this point, I will turn it over to Amy for a word on exhibits.
Hi, everyone. Can everyone hear me? Okay, so when we're talking about exhibits, the first thing that is important to keep in mind is why we have demonstrative exhibits to begin with. Really, there are three reasons, one of which is to facilitate your testimony. If you are testifying about a complicated scientific or technical concept, a lot of times I have had experts say, it's just easier if I show you, or they want to graphically illustrate some engineering principle or reference a map. And so demonstrative or graphic exhibits let you do that in front of the administrative law judge. The second is to create an impact on the administrative law judge. You know, there have been many studies about how we only absorb a small fraction of what we hear, but we absorb a greater fraction of what we see. We're visual creatures. The last is specific to the Division of Administrative Hearings, the DOA cases that so many of us spend a lot of time in. And at the end of those DOA proceedings, what we do is we write what we've referred to here in this graphic as PROs, proposed recommended orders. And so we need to go back and mine the transcript and mine the exhibits for citations to prove a point, whether it's, this is the location of the project, this is where the expert did his work, this is, the place where the engineering dynamic occurs. And so graphics should help us do that. One of the things to keep in mind, however, is when you're talking about a graphic, it is very important because there is a cold record, there is a transcript that is being created that we're going to be referring to. Typically, the video is not recorded the way that we're recording here today. And so if your testimony is, well, you can see right there on the graphic, this, and this, or, if you're making references to things that everybody in the room can see, but you're not being specific in a way that you can correlate the transcribed testimony to the exhibit, then your testimony isn't worth much as a source of citation. And so that's a really important thing to keep in mind because you've got to go back to the purpose of the exhibits. Similarly, exhibits that do not speak to the ultimate fact, the ultimate conclusion that Fred was talking about earlier are not particularly helpful. So I've seen wonderful graphics that explain, 20 years worth of scientific inquiry, but they're not tightly correlated with what the actual question is in front of the ALJ. And so they may not be all that helpful. So you need to really work with your attorney to make sure that the thrust of your exhibit and the point of the administrative inquiry are connected. Next slide, please. Now, in terms of electronic display, I'm going to show you a couple of examples that really highlight why it is so important to know what the exhibit looks like on the screen. When, say, we're on the telephone and you and I are looking at a PDF together, very often you'll zoom in on the PDF, you'll try and expand it. But a lot of times, because the native graphic is so detailed, or the resolution isn't what it needs to be, say you're working off of a PDF, important information is not legible in a Zoom proceeding. And so, you know, whether it's a legend, whether it's a source citation, you need to make sure that all that information you're going to be testifying about is going to be legible to the person on the other side of the Zoom proceeding. Similarly, if you're using you know, different formats for, and particularly for a dynamic document, whether it's a simulation or a video that's been annotated in some fashion, make sure that it can play in whatever hearing platform that you're using. Zoom and WebEx and Teams all have their own peculiar technical glitches. And so it's the last thing you want to do, to spend a lot of time on an exhibit that you can't provide. And it complicates your testimony if you've planned it around showing things in a document that can't be played. Naming conventions are very important. In the case that we just had, that Fred was talking about earlier, we were referencing source data, and the source data, you know, had Excel document file names like sampling data. And there's like 5 different versions of that document. And so during the testimony, we had to go through with the expert and say, is this the final version? Is this the version that includes both sampling sets? And the expert had to say, well, I don't know, move to this spreadsheet, you know, page. Looks like that's filled in, so I think it's probably the most recent one. Save yourself all of that hassle by being careful about how you name things. And you can name things to give yourself, you know, a better understanding of the location, the date, the creator. There's all sorts of information that you can embed in a file name. And lastly, consider indexing or creating a graphic that helps you in testimony know where was the, you know, the site visit, where were the photos taken, where were the videos taken, you know, what section of the project was the simulation done for, what source data goes to which simulation event. Make sure that you've got connections between that basic, you know, data and the graphic that you're showing. Next slide. So this is an example of a document that came from a pre-Zoom hearing, and it's a good example of how something that played very well in person, because we were able to blow it up and put it on a huge foam board, is probably not going to be all that helpful in a Zoom proceeding, because, you know, it has a lot of little details associated with each of these red dots, and that you wouldn't be able to see even if you blew it up. And it's busy. And so if you were going to use something that looks like this, this is an aerial with sightings of manatee overlaid on top of it. What you would need to consider are things like call out boxes to show, you know, particular sections. You might want to consider breaking it up into a number of different exhibits. You might want to think about adding additional legends for clarity. And you might want to think about all of those little white boxes represented numbers. And in that particular case, we had a problem because the numbers related to numbers that had something to do with the source data, but didn't correlate to exhibits that showed those pictures. And so, you know, it was an important lesson for the expert that when you're creating a graphic, make it easy for the connection between exhibits and the graphic by cross-referencing exhibit numbers rather than source data, where it becomes very complicated to use it as a source of citation in the PRO. Next slide. This is another exhibit from a pre-Zoom hearing that I think probably would play a little bit better in a Zoom hearing. It's more legible, it's well labeled. You see the word provenance. It's very important as an expert that you're able to say what the underlying graphic is. Where did that aerial come from? Where did these dots that are representing you know, sightings of certain kind of species come from? You know, where did the little yellow graphic of a project come from? And so in this case, at the bottom, you can see some information about where the aerial came from and where who it was that created this document, and all of that will assist in testimony so that you will be able to testify and say, you know, the data that I'm using as the basis of my expert opinion can be identified. It is appropriate as a basis for expert opinion, and I can ground my my opinions in material that is appropriate for the kind of hearing that we're in. Now, the cons of this is maybe it's a little bit bland, and it does require some interpretation by the expert to let the viewer know what it is you're looking at. And without that kind of interpretation, it might be a little bit harder to cite in the PRO. You know, if I were going to write a PRO and say, you know, there were this many citations of birds within this amount of time, I couldn't do it just based on this image. It would take me doing a little bit of math, and it would take me, you know, mining the legend for some information. I would really need that corresponding testimony. And, you know, there are going to be pros and cons with however you develop your exhibit, but thinking about how it's going to be used on the tail end is going to get you farther to having a document that's going to be really useful for your client. Okay, the next one. Okay, I mentioned call out boxes before. This is an example of an image that has call out boxes. It's a punchier graphic because the ALJ is able to associate very specific photographs with locations. And so it's going to be much easier for the expert to say, you can see in the top left-hand corner photograph that we're looking at as such and such, and we saw this on this day. And it's going to be easy to organize the testimony around the call out boxes in a way that the ALJ will be able to follow. And it would be easier to cite for the PRFO because of that same kind of organizational structure. The cons of it is it's a little bit busy. And another con that is an important thing for you to think about and talk to your lawyer before you create your exhibit is whether or not the structures that you are looking at or the structure of the testimony is such that having one exhibit that covers multiple topics is going to work with the way that your attorney is going to present the information. They may want to talk about plants at one point and then talk about birds at another point. So if you've got an exhibit that covers both, it's going to be weird. So you need to coordinate with your attorney to see if putting information in a single exhibit is going to support the narrative or frustrate the narrative. Next slide. Okay, back to this is another thing of showing boat sightings and manatee sightings. And one of the things that I would encourage you to think about is when you're creating a graphic that has something like sightings or something like sampling, be thoughtful about the timing and the context of that sampling, and think about how you're going to indicate it on the graphic so that you don't lend you don't fall into a trap of being accused of making something that is misleading. You know, you don't want the attorney on the other side to say, well, this looks like it all happened in the same time, but in reality, it's over, you know, this amount of years. If you have an appropriate legend that creates that context, you're less likely to be challenged. And also, if you're working in a firm and you have a subordinate that is creating these exhibits for you or consolidating the data, as the testimony, the person who's offering testimony, please make sure that you know the source of the data, how the data was crunched in order to create the dots, how the how the data is being reflected, because you're going to be asked all that stuff on the stand, and your graphic that looks beautiful may not be probative evidence if you can't explain how it came into being to the LJ. Okay. And I'm sorry I'm going fast. I'm just trying to make up for time. Along the same lines as what I was just talking about with, understanding the methodology of the exhibit, you need to talk to your attorney about whether or not you are the right person to sponsor the exhibit into evidence. Do you know enough about the photographs, the video, the source data? You don't have to be the person that took it. You simply need to be able to say it's a true and accurate depiction of what is being depicted. And you need to be able to say what the source data is and that it's something that's reasonable for you to rely on as an expert. But you need to understand your exhibits fairly well in order to testify in a way that will get that exhibit into evidence. And one thing I would caution you on is, for many of our experts, they have been working in the field for decades before they ever come onto our legal team for a specific case. And so you may think that you've got prior exhibits that are going to prove the point, and they may prove the larger scientific point, but you need to go back and revisit those graphics. Are they based on up-to-date aerials? Are they based on up-to-date, survey information? Do they truly speak to the ultimate question of fact? Because case theories evolve from the time that the petition's filed until the final hearing, and they certainly evolve from the time that you first, started thinking about the topic, which may have been during the permitting process or even earlier, all the way to the time that you're at final hearing. So go back and revisit your graphics to make sure you don't have an uncomfortable moment on the stand when you realize, oh shoot, I didn't incorporate that new information into the final graphic. Next one. And that's it. Sorry, I talk like an auctioneer. We're very happy to take your questions. And I know that I speak for the team when I say thank you very much for your time and attention today.
Thank you, Amy. This is Kelly. I just wanted to thank everyone for your time today and thank the presenters, of course, for a great presentation. We'll open it up for a few questions. We already did receive a couple questions, so I'll go ahead and read those. One question is, what is the guidance on fees for expert witnesses? And then the second question that came through is, does a court reporter have to be present during the Zoom deposition?
I'll take a shot at those, and they came in from DJB Engineering. I think that's you, David. So my guidance for fees is you have a standard rate, I'm sure, in your normal day-to-day operations. I would advise you just to sort of charge that as your base rate. Now, there are people who charge sort of an increased fee for providing testimony. So when they're actually being deposed, when they're actually providing their testimony, I personally don't like that. It makes it, to me, it makes it feel like that testimony is bought and paid for. But there are people who do it. Some clients won't pay for it. I know I work for one client, it's a state agency. They won't pay that accelerator. And so you get your base fee. So that's sort of a business decision that you have to make for yourself. As far as the court reporter, yes, in order for it to be a deposition that can be used later, it has to be recorded. It has to be sworn testimony, and then it can be used against you later on in court.
To add to that, though, Fred, I think that perhaps it's important to note that in the Zoom era here, there is a pursuant to Supreme Court rule, there is now a stipulation that gets read at the beginning of every proceeding where the attorneys agree to the stipulation that the court reporter is not in the same room as the deponent. And normally it starts with the deponent having to show some form of ID to the, wave it up to the screen for the court reporter to see, to verify that the person being deposed is in fact the person who is supposed to be being deposed. I agree with Fred on the fees question as well. Certainly, you don't want anything that's identified as a bonus for testimony, but in terms of how high you charge, doesn't matter. And really, your fees in the context of an administrative hearing is almost a wasted question in many circumstances, because the administrative law judges really don't care.
Well, and if I could talk about the fee issue just for a second, if there is in the rule of civil procedure that when you're being deposed and you're an expert, the other side is supposed to pay for your fees. Now, sometimes the parties agree to each pay for their own, but if they don't have that stipulation, then the other side has to pay you in order to depose you. If your hourly fee is too high, they can go to the hearing officer and say, they're trying to charge me an amount that's not reasonable for the kind of expert that they are. And the hearing officer can say, okay, yeah, I think $1,000 an hour is too high. I think the going rate is $400 an hour or something like that. So something to talk about with your attorney. And another thing about structuring fees for final hearing, if you're going to cool your jets for a little while before you testify, you probably want to address that with the client on the front end and say, you know, a hearing day, I have a minimum number of hours, or, you know, I'm getting compensated for standby, or whatever it is, so that everybody's clear before you send the invoice on how you're going to handle those issues. So just a couple of extra thoughts. We could probably do an entire day on fees, but those were the things that came to mind for me.
All right, thank you very much. We also just received a question from Jay Cox. The question is, how do you reach to your lawyer seeking an objection if one was not forthcoming, but you feel was out of order?
So I guess my question is, as the expert, how are you determining that something was out of order and is therefore objectionable, unless you know that your answer would require the information, it would require you to divulge conversations with the attorney, which are protected. And that's something, so obviously today is a lunch and learn. Preparing experts for their deposition is a multi-hour process. And one of the things that we would talk to you about is, if you are in fact required to divulge something that would be the contents of a conversation with me, and I don't pick up on that, then you can say, the only way I can answer that question is to divulge conversations with Mr. Ashar, at which point I would say, well, don't do that. I'm going to object as to privilege, on the grounds of privilege, keeping in mind that at depositions, we're actually very limited in the objections we can make. I guess the other thing is, you might feel like they're now sort of being a little bit bullying with you. That's a tactic that attorneys use. The truth is, we could talk about that. If I let it go, or one of us lets it go, it's because we've seen it, and it's behavior that unfortunately is, I won't say acceptable, but maybe routine. And you sort of kind of got to let that go and put that aside. I hope that answers your question.
Yeah, I mean, so my thought on that, just to add a little bit of extra kind of 2 cents, is typically you're not allowed, if there is a question pending, to stop and talk to your lawyer. So if you've got an issue, you actually have to say it out loud in front of everybody. You can't say, hey, Fred, can I talk to you outside for a second? There are some questions that feel very personal that are actually allowed within the rules. So for example, asking about your criminal history, asking if you're on any medication that may affect your testimony, asking, who lives in your house and how old they are. Those are questions that feel kind of threatening, but are actually allowable because they relate to either the veracity of your testimony, your competency to offer testimony, or the ability to effect service on you, respectively, each in the case. If it goes beyond that and you feel like you're being asked private information that you don't want to divulge, I would simply, if I were you, I would say, I'm not sure what the point of asking me personal questions are, and I'm not comfortable with answering that question. And you may want to take a break and talk to the attorney, but understand that typically is not something that's allowed, and it's going to result in further motion practice. But having said that, I mean, you don't have to take abuse, ad infinitum. You're a human who has your own rights. So, put it on the record that you're uncomfortable.
All right. Well, thank you very much. I don't see any other questions coming through the chat feature at this time. I wanted to just
Kelly, I I'm reading one that I don't think you've read.
Oh, I see that. Yeah, it just came in from Jason Everett. The question is, as attorneys, do you find it more time consuming in terms of preparation and execution of hearings, trials, etc., in the Zoom landscape or in person?
I think Zoom takes more time personally. There's just more logistics to talk about. And the other thing is for depositions, I think that you end up having to produce documents in advance just so that everybody's looking at the same things. And so it requires a greater level of prep than you might have otherwise. I personally, though, don't think that's a bad thing. I think we end up being slightly more thoughtful about it because of the logistics issues. So, but my personal experience is it takes a little bit more time. I don't know, Fred and Kevin, what y'all think.
Well, just to be the contrarian, I'll argue that there's time-saving advantages to the Zoom, mostly in terms of travel. I have to put as much makeup on as I would if I going to court. But in terms of the strict preparation, all of the kind of preparation that Fred was talking about, I think it's about the same. It's more content differences or go into a lot of what Amy was talking about in terms of we need to work on what the exhibits look like over a Zoom platform, and sometimes I find more time with all that zooming in and out of an exhibit, and some frustration sometimes when the magnifier jumps from 50% to 1,000%, but for the most part, I think that the reality is, particularly with hearing times, people will fill up as much time as they're allotted sometimes is what it seems like to me. So anyway, Fred, you had any additional thoughts?
No, I think for someone who travels a great deal, for the case I work on, Zoom can be a time savings in that regard. So,
Mm-hmm.
Yeah.
So it looks like we have two more.
Oh boy.
Yeah, we just got in two more questions, and just in case if folks have to jump off the call, I wanted to let everyone know that we will be circulating a recording of today's session. And if you have any more questions, please feel free to email them to me or to the presenters. So if you have to jump off, feel free to do so. But we do have two more questions, and I will address the first one from Jay Cox. Do we, as the experts, call up our own exhibits, or will the lawyer bring them up?
Well, I personally like to handle the exhibits myself. As I indicated before, there are times when I want to keep that exhibit up, certainly through maybe cross-examination or other reasons that I feel that I want the judge to see that, and also I want to be able to take the exhibits down if I want my witnesses to be seen, or be in charge of Zooming. There are times though when you want the ability for the expert to be the one pointing to an exhibit, or even writing on an exhibit, which may require that the expert have control. And then the other thing is that there may actually be things that experts engineering, the exhibit may be in a format that I simply don't have on my computer system, and so I'll need it to be shown through your system.
Yeah, some firms actually will hire a technological expert that kind of serves as an electronic Vanna White, and they'll post the image at the appropriate part of the testimony. And then as you talk, if you say, you see that little dark spot in the middle of the thing, and they'll, draw a circle around it. or you see what it says in the second paragraph and they'll pull a call out box out of it. Fred and I were very jealous in a recent case that the other side had someone that was really good at it. So, you know, ask your attorney if they're going to have technical support staff like that. And, you know, because the tighter the coordination, the more persuasive the testimony. There is no absolute requirement that it be the attorney, but typically the attorney, a paralegal, or a tech support person will be in charge of that.
It occurs to me that these questions are coming from Jack. And I think that what that means, Jack, is that I think I taught you to think too much like a lawyer last time we worked together. But they're actually both been very, very good questions. And my very brief answer to add on would be, if you need to see something, tell me. If you think, you know, because I can't read your mind. If you think, well, you know, that exhibit 37 that you showed me earlier, can we pull that back up? That's honestly, if you're saying stuff like that, I'm going to give you a big slap on the back when it's all over, because that the judges, whether it's a circuit court or ALJ, pictures are worth 1,000 words. So.
All right, it looks like we have one final question from Danielle. Is our Zoom hearings here to stay?
Yes.
In one way or the other, I think so. Yes.
Yeah, you know, if any of you have done the old video conferences in the Division of Administrative Hearings, you'll know that those were cumbersome and that the lawyers hated them and the ALJs were not big fans. But the Zoom hearing that we just finished, the ALJ was tickled pink with how it went. And, you know, the Division of Administrative Hearings, I think they're probably going to be looking to save on travel costs. And so the closer that they can stimulate an in-person experience with these kind of platforms, the more likely they are to strongly encourage the parties to do this. And then also the clients. I mean, you know, they talk about litigation being the sport of kings, and the more expensive that the process gets, the more invested they're going to be in saving things like travel costs and in-person appearances. So I think that, you know, this experience has changed workplaces for hearings, for depositions, and for all of us. And, you know, there's no putting the devil back in this box.
Yeah, I agree. But Danielle, if you and I are working together on a project and you're going to be deposed and it's going to be via Zoom, you will find that I am going to insist that you and I be in the same room. Post-COVID, once we've all returned to normalcy, I find the interaction between myself and my expert to be critical, and it is it's a different experience when you're live and in person with the person. And also, if we are separated and we're in different locations, and this happened I was just actually reading the transcript of that trial we just did. It was 2 weeks, and at one point I got cut off, and I couldn't say anything, and so I had to come back and say, Judge, I'm sorry, but I had no audio for the last 3 minutes. Can I have the last question read to me? And we had to sort of figure out where I got cut off. That could be a big issue if you are still talking and I'm in somewhere else and I get cut off. I can't properly object or anything like that. So I think you'll see that I will insist that once we get back to normal, I'll insist that at least we are in the same room.
Sounds good to me.
Thank you, Danielle, for your question. And thank you, everyone else, for the wonderful questions that you submitted. I'm not seeing any other questions come through in the chat box. So I just wanted to thank the presenters today. And again, thank everyone that participated for your time today. As I said earlier, there will be an email that we will send out to you with a copy of the recording, plus a quick survey. If you don't mind taking a quick survey, letting us know how we did. Also let us know if there are any topics for future lunch and learns that you would be interested in. And of course, at any time, you can send me an email if you have any questions, or send an email directly to our presenters if you have any questions. So with that, I just hope everyone has a great rest of your day.
Stay safe.
Thank you, everyone.
Thank you all.
Thanks, Al. Bye-bye.